Hello, I'm Jim Finnerty. With another holiday season upon us, school districts nationwide are busy planning parties and events. Holiday socials are a long-standing tradition as a way to thank employees and to also celebrate annual accomplishments. They can, however, also serve as the breeding ground for employer liability, especially when alcohol is served. A 2000 survey by Vault.com found that 44% of employers had to reprimand an employee for behavior at a company holiday party. A 2010 poll by the HR firm Adecco corroborates findings that 40% of people surveyed saw or suffered a major indiscretion at a work-sponsored holiday event, and 14% knew someone who was fired for bad behavior. Our guest today is attorney Elizabeth Eisen. Ms. Eisen has been engaged in the private practice of employment law since 1988. In 1996, Ms. Eisen opened her own practice in an effort to bring superior labor and employment law services to small and mid-sized employers. She's a frequent lecturer and trainer on employment law topics. Elizabeth specializes in conducting neutral workplace investigations for public and private sector employers. Thanks for being with us today.
Yes, thank you for having me.
I've got several questions that deal with this whole area of holiday parties and what's appropriate and what's inappropriate. Let me start off. You've been doing this for 20 years or more. Let's talk in a broad range about some of the legal issues that employers need to be aware of when they're even planning the holiday party.
The chief complaint is sexual harassment. In addition to that, we worry about third-party liability. Somebody drinks too much at a company party, goes out and drives and hurts another individual, and also workers' compensation liability.
Let's start with sexual harassment. Let's talk a little bit, because I know that sometimes is confusing to some people. What constitutes sexual harassment?
Well, there are two types of sexual harassment under the law. The first one is quid pro quo, sleep with me or you're going to lose your job. And that's where someone uses the power of their position to coerce a sex act out of someone. The second type is a hostile work environment, where the whole work environment is inappropriately charged with comments and behaviors of a sexual nature. And that's what we worry about at a company party. People drink too much, they get comfortable and relaxed, they might tell inappropriate sexual jokes, touch somebody inappropriately, wear something that's sexually provocative, or maybe give a sexually provocative gift.
Now, if somebody who's involved in doing one of those acts, is that a violation of state, California, and or federal law?
Yes, California and federal law prohibit sexual harassment as a form of sex discrimination. So sexual harassment is one small subset of the much larger category of sex discrimination, but it certainly is against the law.
So let's talk about then what happens for the employer. What does the employer do if he or she or the company gets a complaint about sexual harassment taking place in one of these situations?
Good question. If the employer, manager, supervisor, an agent of the school district or the organization hears that someone was uncomfortable with inappropriate sexual behavior at a holiday party, they have to, by law, conduct an immediate workplace investigation. And that's actually your first line of defense and your best tool. So you can do the investigation in-house, or you can bring in a third party to do an investigation. But no matter how innocuous the complaint, the employer wants to look into it.
Let me take that a little further. Is there a liability, a personal liability, if an employee, let's talk about an employee in this particular case, engages in sexual harassment at one of these gatherings?
Yes, and I don't think a lot of people realize that, but under California law, which is a little bit unique, everybody's personally liable. So if you sexually harass me in the workplace and also at a company party, I can sue you personally and go after your toys, as I call them. I can try to garnish your wages, take your car, maybe your house, but everybody's personal assets are on the line.
Let's talk about that other area which you mentioned at the beginning as well. Alcohol-related driving incidents, such as there might be an accident, or somebody might be involved in an accident, or not even an accident, just get stopped and a DUI is involved. Let's talk about that for a moment.
Well, every year, the California Highway Patrol reports that 2,000 to 3,000 persons are injured or killed in California alcohol-involved collisions in the month of December. And other statistics indicate that 20% of people who are intoxicated at a workplace party will get behind the wheel.
Now, is the district liable if an employee drinks too much at a holiday party, perhaps leaves, drives intoxicated, and in a worst case scenario, gets involved in an accident where somebody is hurt. Is the district liable in that particular case?
Possibly. Under what's called respondent superior, it's a negligence theory. So if it's very known that an employee is severely intoxicated and an agent of the employer allows that person to drive and does nothing to stop them, and they go out and kill someone or injure someone else, possibly the district could be on the line.
Following up on that, what about injuries suffered at a holiday party? Is the district's, I guess in this particular case, workman's compensation, would that become involved in this whole issue as to who gets compensation or who takes care of the injuries and hospitalization if needed?
Sure. If there is an injury that occurs at a holiday party that's sponsored by the district, and let's say maybe some customers or clients and vendors are there as well, and employees feel that they need to attend the holiday party in order to schmooze with the boss, and it's an extension of their job, and they're injured, most likely workers' compensation is going to be implicated.
So let's take a little proactive approach if we can. What then can an employer do ahead of time to make sure that we don't even move into discussing some of these areas or have to deal with some of these areas later on after the holiday party takes place or while the party is taking place?
Well, the easiest thing to do would be to not have alcohol at a holiday party, but maybe that's not so fun. So if you're going to have alcohol, have a cash bar, hire a bartender to monitor what people are doing, cut them off if they drink too much, close the bar down early, maybe have a luncheon instead of a dinner, so there's no alcohol involved. If you'd like to do it in the evening, bring your spouse, your significant other, your domestic partner, kids, so that it's a larger group of people, which tends to cut down on the more sexual type behavior and people drink too much. And mostly distribute your sexual harassment policies and other policies that you might have that indicate how people are supposed to behave in the workplace, so that the professionalism that's expected from 8 to 5 continues during the holiday party.
And correct me if I'm wrong, we're talking about holiday party and we tend to think about the end of the year, New Year's or Christmas celebrations or holiday parties. But I'm assuming that this would apply to holiday parties on a spring break party or that summer barbecue that the company might have or something that goes on with a harvest festival. Correct me if I'm wrong, those come into play as well.
Absolutely. Anytime you have a district-sponsored or a company-sponsored event that employees feel that they need to attend, all of these rules are going to apply.
Well, Elizabeth, thank you for sharing this information, valuable information for employers during this holiday season, or as you said, anytime you're having a company gathering or a gathering where you have employees together. We appreciate your time.
Thank you.
And we hope you found this workshop beneficial. We would like to thank you for the service that you perform every day for the students in your district.